Everybody, thank you very much. I think many of you know Justeena already, so I'm not going to do too much of a lengthy introduction, except to say this contribution is a very, very useful and important contribution to a debate that has otherwise been tied up too much, and particularly today in the question of troop increases and how many troops you put on the ground. Justeena's perspective is interesting not only because of the perspective she brings as a lawyer, nor even only the perspective she brings as somebody who's actually, unlike the rest of the fellows in the centre, actually worked within the military ISAF system, but also because of the very broad comparative perspective she brings from other theatres and other zones, and indeed her background initially as a human rights lawyer. So for all of those reasons, very excited to see you. And I'm going to be sitting here in the front row.
Thank you. Okay, welcome everybody. As you've seen from the posters, I'm going to be talking a little bit about one of the key institutions in Afghanistan, institution that we've been working on assisting for a while, and that I think is one of the fundamental issues that we've been unable to decipher and to figure out how our policy should deal with it, given that it would probably take a long time to master. As Rory said, I'm Justeena. I'm an associate fellow here at the Carr Center, and just so I don't go too much off topic and wander off on tangents, we'll leave that for questions. I'll be a little bit focused on my reading so I can be sure that I present all the issues, try and define the concepts. It's a very nuanced, complex issue that I'm trying to do research on, and it gets mixed up with the issue of human rights protection, women's rights, and those are all very important issues. But I do believe the framework that I'm trying to lay out in my research, that I hope I can prove in the field, will address some of those really, really, really key issues. As Rory said, I'm a lawyer, and I'm also previously a social worker. So I come to this work looking at people and how they fit into society and communities, and how the systems in society protect, support, and facilitate their existence in society. I am a lawyer from Canada, and I have an LLM in Public International Law from Leiden University, and clerked at the International Court of Justice. And since that time in '99, I've been through working in a variety of post-conflict and transitional countries, Afghanistan being one of them, but Sudan, Somalia, Iraq, Bosnia, and Sri Lanka, Indonesia, and a few other places. So in all of those places, I've been working with the legal system, on the legal system, in various capacities. Please come in. Lots of seats. For my research, what sparked my interest in this research was my work in Afghanistan. I worked with the Norwegian Refugee Council, which is an international NGO. And I worked in a legal advisory capacity. I was doing legal advice, but mainly advocacy and capacity building of the legal actors within judicial decision-making structures. So that was like lawyers, judges, paralegals, advocates, people who worked in courts, the police, community security, and others. And I took with that, when I went on to work in Sudan, some of the lessons from Afghanistan and in Iraq as well, working with those groups. Adding that all together with my overall experience in law and development, I think I have a bit of an insight on how effective legal and decision-making systems can be developed in these kind of transitional situations. The main impetus for this particular research on informal justice, an investigation of the possibilities of using the informal justice system in Afghanistan, I think has come out of the realization that the formal justice system in Afghanistan and the structures which we are working so hard to capacity build and develop are not really being used to the extent they could be. From my field research, from my talking with Afghans, from my being in the country, generally what the reason for that is that Afghans really don't have faith in the system that's there, and the system that's emerging out of the post-conflict situation, and what what the international community is trying to support. And they find they don't have a lot of faith in it because they look at it as a cumbersome and corrupt system. And that makes it clear that we can't really count on the formal system, we, the international community, formal courts and institutions, to be the sole provider of justice in Afghanistan. And I've looked at the figures lately, and as per the Rome conference, in which the national justice sector strategy in Afghanistan was discussed, we have committed up to about $1.4 million to continue to try and build and support a formal justice system, which clearly hasn't really been meeting the needs of Afghans. And what my main research concern and question emerges out of the questions that are being asked by the international community about how they can better implement policy, programs, activities that best meet the needs of achieving rule of law and justice out of the chaos and corruption that's sort of rampant in the Afghan legal system, formal system, and out of critiques raised by Afghans, academics and activists, that after 8 years of programs aimed at building up the justice sector, there's not much to show. I'll give you a figure, but figures it's really hard to quantify these kind of things, but it's pretty much estimated that more than 80% of Afghan communities use or report that they use traditional dispute resolution mechanisms to address legal disputes instead of the formal system. Now, think about it. There's a lot of use of the formal justice system in cities, but a lot of people live out of the cities in Afghanistan, in the rural areas and in smaller centers. And again, this is a figure that's quoted, and I think among the fellows we always get concerned about quoting figures, but I just think it's important to know that a huge chunk of the Afghan population at least reports that they have more faith in the system, or they use the system more. And they use it mainly to deal with, to resolve civil disputes, mostly family and land disputes, as opposed to criminal law and commercial law, which is pretty well defined in formal legal statute law in Afghanistan, and formal court system is usually usually used. It takes a long time, and sometimes issues get resolved out of the formal court system, and then they just record it when it comes to commercial and criminal issues. But the statutes are very clear. But on land and family issues, in terms of the choice of first instance, very often, more often than not, it's the informal system that's chosen by Afghans. And this widespread use points to actually its utility, the informal justice system's utility, or at least perceived utility by the population. So they perceive it to be better, so there's something there, we've got to look at it. Only in 2005 did the international community start to write this down, quantify this, acknowledge this, and I point to a report that was issued by the Ministry of Justice called Justice for All, a Comprehensive Needs Analysis for Justice in Afghanistan, which was a culmination of a lot of consultations and meetings done by the Afghan Ministry of Justice through the Afghan National Development Strategy and the international community. And there it stated for the first time in writing that it's understood that there are severe limitations and a lack of capacity in the formal justice system, and that the Afghan Ministry of Justice has recognized the need to explore ways in which to link traditional methods of dispute resolution with the formal system in order to address, in particular, as just to go back to it, land and family cases. So there was this acknowledgement that we need to look at it as either a complement or something that should be maybe integrated into the system. And with this in mind, we have to acknowledge and at the most examine the mechanisms of the informal justice system. And my view is that we really can only examine this from the perspective of Afghans, because in the end, as I said in my introduction, this is a fairly long-term endeavor to establish rule of law and a fully functioning system of justice, We have to lay down a roadmap to which Afghans can buy into and work with and want to do themselves. We can't do it for them. And to look and see what the informal justice system can contribute to the overall justice system in Afghanistan, because there's still debate as to, you know, I think the debate is fairly, it's not as contentious as it used to be before, but it is still, there are some questions about whether even the informal justice should be acknowledged as a official system that can be used. So to try and do this research, I started to ask myself questions that I can use in my field research. And this is what I'm here to present today, is a little bit about where I think I can ask questions and what I think, where I think I can make inquiries. And I will give some hints on possible outcomes, things that I think are true and that I will find. But, you know, research goes as it goes, and you don't know. And with all the recent changes in Afghanistan, who knows? The main question, obviously, is what is informal justice? I mean, what is this thing? And within that, the two sub-questions for me are, is the system, what is informal justice and what is its value? So the first question that I ask myself in order to determine that is the system of formal justice that we're using, the international community, endorsing or representing the views of the population that it's serving? And, you know, as I've said to you, from documents issued by the ministries in Afghanistan and policy documents by the international community, it's pretty clear that the formal system is not representing all the views of the population. But again, I would like to do further inquiry into that to see whether there isn't some way of determining which parts of the formal justice system are, you know, parts that the Afghan society would like to keep and which parts they would like not to keep. And the other thing is to look at, when we're looking at informal justice, there are certain mechanisms that are used to adjudicate cases, jirgas, shuras, and there are many other concepts. And these are, because it's informal justice and because it's based on customs and traditions, it's a very dynamic area. It's not that it changes drastically, but it is something that absorbs outside influences in order to make decisions. Therefore, it's almost like an anthropological approach. It's a completely opposite approach to a lawyer. It's looking at how these mechanisms change and adjust to the needs of the cases and to the communities and to the time. And this is where I start to grasp the understanding as to why the informal justice system is very popular. Because I see that it appears to be a more flexible and accessible system. And I think only if we understand the systems and the values of the society who use them and adhere to them can we figure out why the informal justice system and structures are considered a better alternative. Once I've sort of determined that this is something huge and diverse and could change over time, I then have to start looking at where am I going to get some pushback? Where's there going to be some obstacles, and trying to find out what the informal justice system is, how it's useful, and what part it plays in Afghan society's development. And I think one huge stumbling block for us in trying to get a full understanding of the divide and the distance between the two systems is that we actually don't understand how justice is done in the informal system. And partly this lack of understanding comes from issues of power, fear, and ignorance. This is again my view, between and within the stakeholders in the formal and informal justice system, and also from us. I don't know if some of you might have been at a talk that was given by the Justice of the Supreme Court of Afghanistan earlier in the year, I think October, in which he came to share his views on the state of the justice system and his experience, 40 years experience in the Afghan legal system in various capacities as a lawyer and as a defense lawyer and now as a Supreme Court justice. And he was very clear that he was very hesitant to talk about spreading the sphere of influence of the informal justice sector outside of even small communities. In fact, he actually didn't even want to acknowledge that it was a system which could have any use to Afghan society. And that just spoke to me about the fear of the sphere of influence of the informal system impinging maybe on the sphere of influence that the formal justice system has been struggling to achieve for decades. I mean, this is not a formal justice system that just started being developed since the international community entered Afghanistan. There's been historical developments even from the 1920s. There's been 5 constitutions, there's been amendments, and all of them have moved towards some way or form of establishing some formal structures in the justice system. And the narrowness that I observed from one of the actors in the formal justice system, I think we as the international community have adopted that same narrowness in our policy in terms of looking at the formal justice system and that it is the only way to have development in Afghanistan. Again, I do qualify that by saying I think we have a little bit more nuanced understanding in the last couple of years, but there's still, our policy is going forward strictly based on the notion that we must develop formal justice mechanisms, courts, in capacity building. I'll get more into that later. And I think we've done this mostly because the complexities of an informal justice system are just far too many and too nuanced for us to consider incorporating in a short-term policy approach to the development of a justice system. We just can't do it. So we have to do what we can. The second issue is that I think that there's limited knowledge and also, as I said, a limited acceptance by formal justice actors that limited understanding of how justice operates outside of Kabul or big cities or cities where courts function, and that whether it's legitimate. I think the third issue in terms of why the formal justice, the actors in the formal justice system sort of put up obstacles to us trying to make some inquiries into how the informal system and the formal system can come together is that the members of the formal justice system, normally elites, depending on which generation they came from, secular, although Islamic law is formalized in Afghanistan, so there is, a sort of a formal application of Islamic law, which sort of appears secular, but it's actually Islamic. So, but I think that it's a nice, neat package, and it's really, really hard to think about amorphous concepts from an informal system that change as cases come forward, impact that law. I think the fourth issue for me, and I think that's a hard pill to swallow for the international community, is that there's been, billions spent on infrastructure and capacity building of the justice sector, and as I mentioned, the last tranche of money that has been sort of promised goes up to about 1.4 million for future development, and even with all of that and 7 or 8 years of involvement in Afghanistan,
we went from billions have been spent to millions, to 1.4 million coming up.
Billions since we've entered Afghanistan post-Bonn.
Oh, on everything, not just the justice system, but
no, on the justice system.
Shebang.
On the justice system, and since 2007. Donors have promised for the next 5 years 1.4 million.
So they're cutting down on spending?
No, I'm totaling it from the beginning.
Right.
And then...
But you go from billions to millions, that's where my confusion is.
Since we entered Afghanistan in 2001, if you add up the amount of money that has been spent in Afghanistan in the justice sector, it rises to the billions. From 2007 onwards, when they had the National Justice Sector Strategy meeting, the Rome Conference, in which they decided they have things to do in the justice sector, and they quantified it. This is how many courthouses we have to build, this is how many judges we have to train, etc. Donors have pledged 1.4 billion more for the next 5 years.
1.4 okay.
Million.
From billion to billion. Okay.
Sorry, 1.4 million more.
1.4 million more.
Since 2007.
somehow.
Just
confused.
to try to recapitulate, it is a bit confusing. Because that seems as though we'll be spending from 2007 over the next 5 years, 1/1000th of the amount that we've spent between 2002 and 2007.
Yeah, we might be spending. I mean, that's the number. I mean, we may be spending less. I don't think that has really anything to do with the fact that we think that the justice sector doesn't need any more assistance. But I think that donor fatigue and, contributing money to Afghanistan, different priorities have taken over. Troops, other issues.
But actually, the spending from 2007 will be much more than 1.4 million weighted on the justice
in the
sector.
end, it will. I mean, these are just donor pledges.
It'll be hundreds of millions.
Yeah.
At least, if not billions.
But
So the pledge of 1.4 million understates what's going to be spent?
it'll be
Probably.
hundreds of or even thousands.
And I think that, I get hesitant to use figures like we're going to use billions unless I see it. And I have the conference findings from the Rome conference, and this is how much these countries said they would pledge. They probably have to pledge more to do anything significant in Afghanistan.
Okay.
So, and I think in the Rome Conference of 2007, in which the national justice sector strategy was articulated, that money is supposed to deal with issues like, it's supposed to do things like minimize corruption, deal with training and capacity building judicial personnel, and revitalizing and reconstructing courts, government buildings, and providing resources for the justice sector. So there's still a perception, even though the money may be less now, that we have rampant corruption, we have a lack of qualified judicial personnel, enough qualified judicial personnel, and the courts and the facilities within which justice is administered are still in a very bad physical state. So, even with all the money we've spent, I don't want to belabor that point, but it is clear that we've spent a lot more than we probably wanted to, and that we're going to spend a lot more than we really want to, and that we're still not really achieving goals. For me, this really means that there are many challenges that we still face in trying to get the overall picture of how justice is done with these 4 factors in mind. And add to that, there are areas in the country where there's a lot of insecurity, where the Taliban or other groups may be operating, that we're not even really able to communicate with the local population to find out about the functions and how the informal justice system operates, whether people use it. So there's a huge area in Afghanistan that we haven't really been able to do a lot of good investigation to really find out what's going on there. And I'll refer a little bit to justice in the areas where there's insecurity, where there's Taliban, a little bit later in my talk. So we can't rely on the formal justice actors and stakeholders, including ourselves, to inform us about what are the perceptions of justice for Afghans. And we're not able to get a full overview of, where informal justice may be taking place. I don't think we really have a basis upon which to build a policy that leads towards the goal of a fully representational, accountable, accessible system of justice in the formal and the informal sphere. So that is really the sort of impetus that made me want to do more work into this, and knowing that there are many areas that it'll take me a long time to get into, even years. The full sort of conclusion on whether this is really going to work definitely won't happen by the end of this academic year. So what do we know about the informal justice system? Now we know we don't know, and we're really going to be hard to find out, and then we're spending a lot of money on the formal system. We know from field reports of international, local NGOs, think tanks, private agencies, who've done interviews, have worked with Afghans and with internationals working in Afghanistan, both the military and civilian. So a lot of my field evidence or notes or anecdotes come from my own experience, that there's a lot of justice being done out of major cities under the umbrella of the term informal justice. Examples that I have encountered, or that these are ones I've encountered, and there are many more. I'll give you examples of how I've seen informal justice mechanisms work in 2 regions of Afghanistan. And this may assist a little bit in the understanding of the key reasons why this system persists and pervades justice and legal development. In the north of Afghanistan, looking at the following provinces, and because these are provinces I worked in, and I know there are a few people here who know the provinces, but for others who aren't, Balkh province, Jawzjan province, Saripol province, Faryab province, Kunduz province, Takhar province, Samarkand, Baghlan, Farah, and Herat. It was my observation from fieldwork that even though the infrastructure of the formal judicial institutions was either intact or just mildly damaged, but still functional, that the judicial officials tended to refer cases of civil, usually family or land cases, back to the community. So even though the courts were functioning, they were there, people could go to them, they would get justice with delays, with some corruption. Still, even the judicial officials tended to refer those cases out back to the community. So it was almost the model we think we want in Afghanistan, which is that the formal system's there, but people can choose to resolve their disputes outside, or judges can refer them outside if they feel that, there's mediations could be possible. And then, because the formal system was functioning, what the judges would do is recommend the parties to come to an agreement, a la Western style, and then recommend the parties to come back and register the decisions in the courthouses. So this is something I know from my work as a lawyer in Canada. This works. And I always encouraged people to register the decision in those places just to have a backup, even though when community justice has when the community has resolved an issue, having a piece of paper from the court doesn't always give you any more doesn't give you any more leverage with the community, but for some people a piece of paper is important. And it's important to note that even with the formal system and its adjudication of this process or acceptance of this informal justice decision, there was no promise from the court of assistance to execute or implement that decision. So either informally or formally. And as sort of a quote from the Mazar-e-Sharif district prosecutor who said to me, I said, why do you do this then? You do this, formal court system, get an informal jirga to resolve the issue, people come back, they get a piece of paper, everybody's happy, but no implementation. He said, look, it's my view, according to Islam and traditional custom, shura and jirgas are always encouraged as the best way to settle disputes, as shuras are a historical part of the social life of Afghanistan from ancient times. So it was like a traditional thing. It was just a feeling of tradition, and I wasn't sure whether, after hearing that, whether this idea that a case that was registered in the formal court, that was sent out for mediation, that got registered in the court, was actually being done to create a more efficiency in the process, or just being done out of tradition. But again, these are preliminary findings, but I think there's something to work towards in those communities. In the south and the east of Afghanistan, when it comes to informal justice, it's very different. I have been collaborating with one local NGO, one international think tank, and then of course I covered Nangarhar province when I was working there. And in general, this is all generalizations because this all has to be confirmed, quantified, and proven by research. Informal mechanisms are preferred by the community and even the state to resolve disputes. Since from the point of view of people in the south and the east, informal dispute resolution mechanisms are far more responsive. And from the government's point of view, they're actually far less strain on their resources. The provincial governments just feel that if it can be resolved in the community, we don't have to actually spend that money on developing the formal court system. We can actually let the communities decide. And this is findings from the most recent study that's being done in Ngos province by TLO and USIP. The main impetus for the provincial government to support this, for the provincial governors to support this, is basically because having outstanding disputes created a lot of tension and insecurity in an already tense and insecure environment. So it was in their interest to support these dispute resolution mechanisms. And in Ngos province, as an example, it wasn't a jirga that was formed, but it was something called the Commission on Conflict Mediation, CCM. And the Commission on Conflict Mediation was basically an institution, an informal institution that arose after an ad hoc jirga was held that, resolved issues and disputes. And the international community and the local community thought, well, let's formalize this a little bit so that it actually continues to function. So it's still being tested, but it has now resulted in creating a lot more cohesiveness between the formal and informal systems, security in the province, and a less strain on resources. So this is an idea. It's something that's happening. It's something that's going on. How it's going to pan out and how it gets affected by the different skirmishes and insecurity that rises in those provinces, one can't tell. But normally, these things can go on. And this Commission on Conflict Mediation doesn't actually, which is interesting, deal with family disputes too much. It deals actually with a lot of land-related disputes, access to water disputes, disputes that affect the community as a whole, which is very interesting and new. Now, just to sort of put the informal systems, place the informal systems into context with the official development plan and strategy of the formal system, I just wanted to list down a couple of policy assumptions or conventional wisdoms, as we're calling them now, that sort of lead us to believe that the formal justice sector is key and the informal justice sectors are not key to the development of justice in Afghanistan. Why we develop our policy the way we do and we ignore the informal justice system. And they're flawed assumptions in my view. So this is my opinion, and hopefully my research bears that out. One is that the international community tends to believe that Afghanistan is lawless and devoid of meaningful legal structures. So that we came in and there's nothing getting resolved. Now, not everyone believes that, especially people who've worked in Afghanistan for a long time, especially policymakers are coming to that realization, but the general public. And that's what keeps the general public in the West bought into spending that much money on development of systems which may not be meet the need. The other flawed assumption in my view is that foreign intervention is really the only way to ensure rule of law can be achieved in Afghanistan. That it can't really emerge out of the local population's decision to resolve issues and to develop their own structures. We need to help them. And a sub-assumption to that is that in that vein, then, we use Western concepts or non-Afghan concepts to develop the policy and strategy for building judicial institutions and the legal system. So we don't even really open our mind to these kind of CCM or jirgas or shuras, because we have this fear that if we don't implement the justice system in a way that we understand it, that in certain areas another system of justice might take over, something that's brutal, violent, in opposition to human rights. And there is obviously some places where there has been cases, and I'm not minimizing it by saying there has been cases. There are situations in which many practices within the informal system is not really checking and ensuring that certain human rights are not violated. And since we aren't monitoring it, since we don't have access to all of it, there have been some cases of brutal justice. But I still believe that that is not what the informal justice system and what customary law and traditions really emerge out of, and that then doesn't make sense to throw out the whole concept of informal justice. It means look at the concept as a whole and tweak it and look at it in terms of how Afghanistan emerges in today's world in relation to development of justice globally and communally, within itself, community. And for me, the reason why I think it's even worthwhile investigating the informal justice system and the mechanism through which it's implemented is that Afghanistan does have a long history of legal and judicial and institutional development that's documented and functions. And outside of the urban areas, because the urban areas is where it is mostly documented and functional, outside of the urban areas, it's dispute resolution is characterized by a strong, decentralized, informal dispute resolution mechanisms that have been used successfully to resolve issues in a fair, impartial, accessible, and sensitive manner for decades. If you ask people, they will tell you. And from the research and work that's being done, getting perceptions, hearing the perceptions of Afghans, they do perceive the formal system as inaccessible and corrupt, as many other institutions in Afghanistan are perceived as corrupt. See a member of the bar here, so just trying to be diplomatic, but he nodded. So really, why is the formal system not working? Well, I mean, distances people have to travel to get to courts, communication, updating on their cases, how do they know what's going on, literacy barriers, financial resources. There are a lot of court fees. I mean, I've been in Afghanistan and done cases, and there's a fee for pretty much everything, and it's hard for people to travel and to pay court fees, administrative fees. And distrust of the formal judicial officials, judges, and others who are perceived as corrupt. But a lot of that has to do with, I mean, until actually there has been some improvements in terms of judicial salaries and payment of judicial salaries and resourcing of judicial institutions, which I have to believe has had some impact on the corrupt nature, but we can deal with that in questions. But I still think that there's still a perception among the population that it's not the place to go. Another factor impeding the use of the formal system is really the massive destruction of formal buildings, court records in some cases, buildings that need to be rebuilt, and in places where there isn't really security to do that, to rebuild those courts systems. And then just a basic usual problem that happens in Afghanistan or in post-conflict countries in development, which is this lack of coordination between stakeholders, between Afghans, international community on what actually to do first and how to do it. Although we have the National Justice Sector Strategy now, but just like any national strategic document, it's long and broad and with a lot of objectives to achieve in a short period of time. And because of the earlier reasons that I mentioned about just now, the stakeholders and the interest in the formal system, it appears that the informal system has become a viable alternative. And specifically for the reasons below, the formal system is not trusted for the reasons mentioned above. And also other research that's being done. Earlier this year you heard Andrew Wilder, Dr. Wilder, talk about perceptions of Afghans in aid. And although that's a more general topic, one of his conclusions and areas for further research was that Afghans did report in answers to the questions that they do still perceive, even after all the billions, this time billions, spent on aid in general in Afghanistan, that they still don't perceive that they have security and justice. So there's a perception that they don't have that. Whether we can quantify how many courthouses we've built and how much security we've provided, it's not really obvious to local communities. And he did, of course, do a sampling of different areas. So I wouldn't say that he knows the whole, that we all have a perception of what exactly is going on in the whole country, but certain key areas where aid is really, really pumped in. So he picked areas like that. And also other surveys and reports. Recently, Asia Foundation released its State of the Afghan People report, the usual report it releases every year or a couple of years, looking at, it's almost like a poll in a way, but a longer report. And Afghans confirm that they perceive they have no access to formal judicial mechanisms. And they don't believe that formal judicial mechanisms guarantee rule of law. And so they constantly turn to the informal system, to local dispute resolution mechanisms, to shuras, jirgas run by respected elders to deal with their legal problems. Knowing all of that, knowing that the formal system doesn't work, knowing that there's a confusion about where to start with the formal system, I will venture into, in the last couple of minutes, how I think we can start to look at the informal system. But really, this is preliminary and really has to, further research has to be done to bear out anything that I'm saying. Although I think my experience in the country, and I believe my knowledge of the area, I think I'm pretty much on target with questions. The first question I think we need to ask is, before attempting to make a policy or develop a strategy on governance and justice, is to find out what Afghans perceive as the values that underlie good governance and fair justice. We talk a lot about what we think Afghans perceive this and that, and we actually have never really figured it out, mostly because we're not, and maybe there can be another way of doing the research. We do know that people persist in using the informal system, even in light of the encouragement to use the formal system. So they persist in using these systems, even if sometimes they will experience violations of their rights in using that system. And that is a little bit mind-boggling to us sometimes, but it's clear that they do. They would rather go with the familiar than with the unfamiliar, corrupt, and it's a reality. To look more into that, into why. Maybe the perceptions that governance and fair justice that we hold are not something that is the foremost in someone's mind when they access the informal system. And some of the reasons that they may want to continue to use that system that are important to acknowledge as reality, and some of the reasons that I've sort of come up with from talking to the communities are, it bolsters their identity in the sense that it's a legal system that reflects their values, something they understand, and sometimes something that emerges out of the Afghan identity. It's really important in the Afghan context for people's identity, and when I say that, because it's a decentralized, tribal, and diverse culture, being able to access a system, a dispute resolution mechanism, a jirga, a shura, a community which reflects your values, your own tribal group, your own socioeconomic status, your own communal values, is very, very important. And that has to be recognized, this pluralistic landscape of Afghanistan, that different things might work in different places. And as part of that, and furthering on to a third reason, it helps people maintain their individual pride in their own tribe or group, in light of this sort of, the approach of us in the formal system is to mainstream or homogenize Afghans. And that's, I don't think, natural. So sometimes people use the informal system as a way to rebel against this homogenization, not really because the informal system is something that they feel has a greater value in terms of justice. It's a reaction. And we have heard that in other areas in terms of why local communities don't report that there are Taliban in the area. It's almost like this is our community, this is how we do what we do, and we don't really want to enter this huge policy approach where you're trying to bulldoze everything into a certain framework, sort of a reactive thing. So knowing this, that this is very nuanced and confusing, I, start to ask myself questions about how we need to define the Afghan context and Afghans, the sort of characteristics that might make someone prefer the informal justice system and also use certain mechanisms within that. And, you know, I've already touched upon them, but just to list them, things like the ethnic diversity and divisions all over the country. So their ethnic diversity and then their political divisions. So, you know, their alliances and things like that. There's class and population distinctions. There always was, you know, the city, Kabul, the elites, and now we have the returning Afghans, and there's a whole class structure and system there, which is like sometimes connected to the tribal and ethnic divisions and many times not. The history of conflict and conflict resolution. So there's been, you know, decades of conflict, different conflicts, which have broken family ties, you know, dispersed communities, brought other communities together, changed family structures, things we have to acknowledge, which may have worked in the past, won't work in the future. And the fourth one for this, which is another paper completely, which I have just written, which is the historical development of the formal and the informal political and judicial institutions and legal approaches. And, you know, legal scholars in the room know what I'm talking about, sort of the historical attempts to constitutionalize and put into statute different legal systems to create more formalization in the administration of justice, then the complete, you know, change into when there was the Soviets in Afghanistan to back and forth. There's been like a whole development of historical judicial institutions, which we have to take into account. There are remnants of that around. So, you know, people like me who work in Afghanistan, you see something and you think, wow, yeah, that looks Soviet times, that feels Soviet, and it's still kind of functioning. Nothing is unified, nothing is, so people are stuck in different time zones, and doesn't mean earlier time zone is bad, it just means it's different. So, you know, it's my view that the development of the informal justice system in Afghanistan has to be studied and understood in those terms, in the terms as I mentioned, ethnic, class, conflict, and institutional development issues that pervade, and they are within the current debate of the Afghan population, between Afghans, among internationals. Just to sort of emphasize why I think this research is important, as I said, none of us in the international community really understand the informal justice system. We have some idea that it's useful and has a role, but we don't really understand it. And so what I'm undertaking is something which may take a long time and may not be successful, which is to try and have an overview. And to even start that, we have to look at things like how communities function. And we have done a little bit of work with that, not in the justice system, but in terms of development in the agricultural sector or in the governance sector, in terms of looking how community councils function or communities make decisions or push policy forward. And so we can learn from other sectors. How Afghans or communities see themselves in relation to others, relations to the formal system, relation to other communities, relation to internationals, relations to returning Afghans, relation to Afghans who are refugees and people who stayed. There's a whole dynamic that needs to be understood. And amongst that, how they resolve disputes. I think that amazingly, given the importance of this institution, where the importance that I've seen in the sense that it is being used and it's so pervasive in the society, it's actually been largely disregarded or pushed aside or discounted as not relevant in the policy discussions that the international communities had about the justice sector. Well, until recently, like I said. And recently, I don't mean 2007, even if it was acknowledged in 2007, even up till today, there really isn't a real discussion going on about how the informal justice system can be a real discussion on the role of the informal justice system. There is a working group that exists in Kabul, in which they discuss one of the provisions in the National Justice Sector Strategy, the only one that refers to the informal justice sector, and they're still stuck on the debate about whether the informal justice sector is even worthwhile discussing. That's where they are now. So judges like our colleague who came earlier, still don't acknowledge it exists, so they're still at that point. And there are a lot of reasons for that, and a lot of people within the international community and the national community believe it has to do with donors and funding, and the fear that funding will get diverted to a more informal sector if the formal justice system acknowledges that it's a more useful justice system. But all the same, we can't move forward. And it's kind of my hope, it is my hope in my research that I can shed some light on how much of a role the informal justice system and traditional dispute resolution mechanisms can play in terms of a positive development in the areas of security and justice in Afghanistan. Because I actually think that that is the key. That's the whole reason I think. And when Dr. Wilder, sort of talked about his conclusion, I was so happy to hear it, because I had been thinking, this is all going on, and Afghans actually don't think that there's a problem with this. And he said his conclusion was that among Afghan communities, regardless of what we've been doing, there is still not a perception that they can access justice, that they can get justice. And just to continue a little bit on some predictions and outcomes of where I think this research could go. I mean, I hold the view that access to justice and protection of one or one's family or community rights are a necessary precondition to ensuring that the wheels of community and Afghan society remain cohesive and stable. And that this system, the informal system, has to be acknowledged, understood, and used, since it's what people turn to when they want to access justice and want to realize their rights. Some of the issues that I hope can lead me to determining this, to provide a basis, a framework upon which the international community can develop some answers to providing an accountable and accessible system of justice for Afghans, are: one, we have to find out what the informal justice system is, and this is going to be a painstaking, widespread, and nuanced research undertaking. So, as I've mentioned before. And we really realistically need to assess whether the informal justice system is going to be able to respect Afghan values and adhere to international human rights standards. Because there are those questions. There are those questions about, it's not automatic that the informal justice system is incompatible with international human rights standards, but there are conflicts, and there are situations in which rights of individuals, especially in terms of the punishments, but that also is the same for Islamic law sometimes, does violate what we perceive as a human rights standard. And so there has to be some discussion and acknowledgement, in particular with vulnerable communities like women, children. So some of my initial thoughts on potential outcomes of my research, what I might find out, is one, that I think the informal justice system would be characterized by its nature of absorbing traditions that surround it into its practice. And since it's been used for so long, before, during, and after the development of the formal justice system, it can claim somewhat legitimately that it has a core standard of traditions that are adhered to in its application of cases that come before jirgas and shuras. So that it actually isn't just amorphous and ad hoc. It has a core set of traditions that we can actually quantify. I think two, I'll find out that it's a widespread it's used all over Afghanistan, and in particular, of course, in the areas where the formal judicial systems are either corrupt or dysfunctional. And also, secondly, in places where approaches and traditions by different tribes or ethnic communities there's a feeling among that population that they need to bolster that. Using informal justice mechanisms can be a way to do that. And There are certain areas in which either the Tajik, Uzbek, Hazara, Turkmen, Pashtun populations have particular, majority, and they want to sort of give a flavor of their approach to justice, and that's difficult in the formal system. It's easier in the informal. And I think that I'll find out something that I already have sort of started to realize is that any approach to justice in Afghanistan has to be more in tune with the needs of Afghan population, its culture, its communal nature, and its consensual nature, consensus building. And in terms of cultural issues, let me think. I've just sort of flagged about 3 things. I've sort of mentioned this before, but when you look at the communal, cultural, and consensual nature, you have to cross-cut that with issues like the superiority of tribal or ethnic loyalties that might supersede something that happens in the formal system. At the same time, being mindful of people who've been in the field and know that these particular individuals sometimes manipulate the informal structures to their own advantage. And so there has to be some kind of a check and balance. 2, that customary practices and traditions and Sharia law are not mutually exclusive, but at the same time, there is some core distinctions that need to be made in terms of whether it's a customary practice, whether it's a religious practice, and whether the finding in a particular case, Sharia law gives customary practices more justification. This is like a huge anthropological concept that I'm trying to explain in 1 minute, but essentially both of those are sources of law that are used in informal justice systems. And the third thing I think is in terms of the consensual nature, the use of elders, respected people within a community to administer informal justice is a very key and important concept in Afghan society, something that doesn't happen in the formal system. And in my experience, it isn't always men. And it isn't always just because the international community has been involved that women have come into it, but women, elderly women and women who've been teachers or been around in the community a while are brought into shuras at least, and have been historically. What are some of the fears I have? This is the last page, of trying to manage this concept of informal justice and to quantify it somehow, define it, bring it into something that we can hold on to and fund and promote and create. One is that we are only going to be there for a short time in Afghanistan. And right now, what we're toying with in terms of the informal justice system is trying to find a way to merge it with the formal system, create some kind of a hybrid system, or merge is integrated. That's one option. Hybrid is this other thing where informal is used for some things and formal is used for the other. And in both of these scenarios, which is being talked about in policy, with the hybrid, of course, you create 2 parallel systems, which is more money, which deal with the same issues, and people will, forum shopping will go around. And the hybrid system puts us in a position where we actually have to make choices that might degrade the values of one or the other. And the last fear that I have, in terms of trying to manage these concepts and define them so clearly within the informal justice system is how it, what is its interconnection with human rights? Now, the way we approach human rights in Afghanistan, there's a very limited mandate on the part of the UN. They don't deal and get engaged in issues of human rights as per violations happen within the informal system, except for on a case-by-case basis, because it's proved to be a very complex issue. And I think this is where actually the core of the research needs to be done, in terms of this informal justice system is something that Afghans perceive as accessible and something they want to use. How can we make that system compatible with individual rights and the values that we feel might make us comfortable to leave Afghanistan? And this is the issue of human rights and informal justice is something which I haven't really looked into too much because I would like to do a lot of field research and I would like to find out what Afghans, how they perceive those things coming together or whether they see them as separate. I think that that's pretty much it. I have some detailed research questions which I'm going to be asking in the field to try and bear out some of my assumptions and try and find out some of the reasons why the informal justice system is popular. But I think I have realized that it is something that is so hard to quantify. I'm not actually sure we're going to be able to do it within the justice sector policy approach that we have in Afghanistan now, especially not now in the next 5 years or whenever we're supposed to be leaving Afghanistan. We'll find out tonight from Obama, I guess, but that's it. Thank you very much. Please.
Could you briefly explain the difference between a shura and a jirga, and could you tell us how the informal system handles a situation where different identities, different ethnic identities are in conflict?
Say the second one again.
Well, supposing it's a conflict between Tajiks and Pashtuns, presumably you might have a case with even 3 or 4 different identities. How would the informal system handle that?
The shura and the jirga, in fact, this comes down to this confusing thing about the informal system. Mainly jirgas are used to resolve legal disputes. So it's like a court case informally. A shura is usually designed for a community to come to some decision about an issue in a community. It could be more of a broader communal issue. It could be a political meeting. It could be an informational meeting. So it's like a broader concept. Maybe Siick can add into that. But I think that that's essentially what what I have observed in terms of a jirga. That's small j jirga. In the political sphere in Afghanistan, no,
I'm sorry, jirga. Okay.
Small j jirga. Keep in mind, in the political sphere in Afghanistan, there has been things called the constitutional loya jirga and the loya jirga. Those are huge political parliamentary meetings, but not to get confused, they're not legal meetings. But my perception in terms of small j jirga and small s shura are the differences. Go ahead.
You didn't answer my question about how the informal system handles identity.
Yeah, I'll get to that. I just think this colleague will be able to add to the
For me,
answer.
shura and jirga both are the same. Shura is an Arabic term, mostly used in like very formal document and stuff like that, while jirga is a Pashto term, mostly used in the south. And both are exactly the same thing. And the way that you explained it, and I don't think if there is any difference between the small j jirga or capital J jirga, both are exactly the same for me. Jirga, like mostly in Pashtun areas, they refer to it as jirga, and north of Afghanistan, which is more Tajik or Hazaras, they would, instead of jirga, they would use shura.
I think that, I worked in the north a lot, and that is in the north. And they would call that a jirga or a shura.
Too, yeah.
Exactly.
Both.
In the north, it was more interchangeable. In the south, it is more specified. From the research that's being done in Ngos province and Helmand province on this, there is, and it's probably from the international community's urging, a delineation of what is a jirga and what is a shura. And I think that it has, again, we are forcing our values on Afghans as usual, but, it has now become the working definition that a jirga is more for legal issues in the south, then let's and Ashura is more for political meetings, but definitely in the north, clearly those terms were interchangeable for the same thing. Among Tajiks, clearly Uzbeks, very clear. In terms of using the informal justice mechanisms to resolve tribal disputes, or is that what your question is? In terms
it could
of
be a tribal dispute, or it could be a dispute that simply happens to involve
different
members
groups
of more than a single ethnicity.
Yeah, I mean, again, just from my own experience working in the north, where there are various ethnic groups engaged in legal disputes, informal disputes, it actually didn't come into, it wasn't an issue. It wasn't an issue in terms of how the outcome of the jirga, whether that person was a Tajik or an Uzbek. There was terms thrown around within the discussion that, oh, he's a Tajik and this is why he thinks that and this. But in terms of whether, the jirga was fully capable of resolving disputes among communities of different ethnic groups without that becoming a barrier. However, sometimes in the outcomes, in the practices, the restorative justice mechanisms, paying back certain things, the decision of the jirga, sometimes there was a decision which had an ethnic flavor to it that may have sort of been made so that it was going to be that the decision would be more adhered to by that ethnic group, using of certain terms, and there are so many customary practices in play that are different by tribe, that if the decision was to try and recover a debt from a certain ethnic group to another ethnic group, there may be terminology used which would make them more, which would encourage them more to follow through with that. But it really didn't make a difference. I think the point is that it would allow them to be themselves and not have to, not have to, how do I explain it? It's really difficult to explain. It wasn't really a consequence, but it was just a pride thing. It's more of a pride thing, and being able to identify yourself for who you are. So it wasn't a stymieing factor in the dispute, and it's fully capable. It's a very flexible system. That's the point. So someone can, when they're in a jirga and they're discussing why a situation has emerged the way it has, why they're in that, for example, situation where there was weapons that weren't paid for, that was the dispute going on there, they might talk about the history of their group and why they came to be in that region and why they have a dispute and why they live in that village and why they ended up having to make that deal with the other tribe. It allowed them to talk about that. Whereas in the formal court system, it doesn't matter. Your plaintiff, defendant, doesn't matter where you come from. It gives people a sense of inclusiveness. You had a question, then 1, 2.
No, I did. I mean, I don't expect you to describe it in great depth, but a jirga, or what's the other structure?
Shura.
Shura. Somebody has a case. Somebody has a grievance. Somebody thinks somebody did something wrong vis-a-vis the family or land or something with the community. So who do they go to, a senior person, and say, I want to have a jirga?
Mm-hmm.
And does that person sometimes resolve it in his home, or right there? In other words, or is it always in public? And do they schedule it for next week, or I wonder how it works? And do they have evidence? Do they have representation, or are there in the informal justice system? Do they always have somebody representing, or is it just the plaintiff and the defendant representing themselves? And is it just that one meeting where a decision is made, or is it extended to So, what is could you give us a vignette or any kind of typical case, so to speak, from beginning? Somebody makes a complaint, and when is it heard, and who comes, and when is the decision made, and then is it carried out? That was another issue. Is it implemented? Can you give us any kind
Depends.
of typical story of a common type of case?
Sure. Well, I mean, just a lot of questions, but if somebody has a grievance and they want to bring it to the community to get resolved, normally in communities, because they're communities, people know who are the elder in the community, the respected people, and sometimes, as we know the structure in Afghanistan now, there are particular commanders or warlords that may be powerful in that area who may not have been powerful before, but have now become a part of the respected group out of, power, influence, status. So people know who adjudicates the jirga. People come and go. Okay, it's not, and people come and go because these things sometimes go on for years. And there's no quantity as to there are 3 hearings, there are 4 hearings. I mean, that's what makes the formal justice sector so apprehensive about this, because, for example, this case, this was 2005 that I took this photo, and this case had been going on for 10 years. Now, one of the reasons it had been going on for 10 years was because a witness whom everybody in the jirga had agreed was a key person to hear from before a decision was made, somebody who knew what money had changed hands and they knew something, had been a refugee in Pakistan. And so him coming back to Afghanistan and facilitating that logistic, I mean, until the international community came along to bring them back, it wasn't really a realizable goal, and at the same time they weren't going to solve the issue because there was no way they were going to come to a decision before that guy. And I was like so anxious to meet that guy, because even though I hadn't been there for 10 years, it was like, who is this guy? He must be famous. In terms of witnesses and hearing from people, you'd be surprised. And again, I'm telling you this from actually being involved and observing and watching these. There is quite a bit of respect in terms of the way people communicate with each other and present information. Quite a bit of acknowledgement that there's corroboration needed. Quite a bit of acceptance that documents are important. And really good memories. So just to make sure I just answered your question. So did you, this case...
It has some resemblance to, I'm not an attorney, but
Yeah.
it sounds like it has resemblance to our legal system.
No, it does for sure. It does for sure. And for...
Informal has resemblance to a formal.
Yeah. And for example, in this case, it was a weapons deal gone bad, essentially. From actually, so 10 years prior, so even it was from the case of the time during the Taliban time, and the case just kept going. So these were all Uzbeks, essentially. I think one guy in there was a Tajik, the witness somewhere in there. And these guys giving their signature are the elders. The disputant is that guy, behind my colleague, my lawyer there, with the kind of blue turban in the corner. That was the main guy that everybody was accusing hasn't paid people. And he had just, bought some weapons, not paid for them, and been living in the community for 10 years. And in the meantime, his sister had married somebody else, the person he had bought the weapons from. So there was a familial ties, and they had just continued to live together with this dispute kind of brewing. And every time some news would come from this famous person in Pakistan, or just some little dispute would go on among the family, they'd raise this thing saying, yeah, you never paid me for that, and it would just go on, and they'd converge a meeting, and then nothing would get decided, and then something would get decided. And I just decided to take control of the situation and bring that guy back, mainly because we were concerned that there was going to be a huge domestic violence problem, because at this point, one of the families was calling for more women from the other family to be married into the other family if they didn't resolve the dispute, and I was trying to prevent that kind of thing. So then we did that. So it has a resemblance, and when you're in it, you don't perceive unfairness at all, in fact. Sorry, yeah.
Can I add something on it?
Sure, please, sorry.
About the members of the Jirgas, it would be like, as you mentioned, 2-3 times. One other possible person could be the mullah, like the religious elder of the village. The person who has more land or is kind of the wealthiest in the village or in the region. He's a certain player in that. And beside that, if they see that this person is kind of like educated or better known, they give a respect for him as well. And for sure, there has to be a representative from both families. And
But back to what you were just saying, to clarify, so would there be one decider, so to speak?
No, it's a
So
consensual.
like a panel of judges?
It's a consensual decision. So when I'm involved in this and I'm watching them discuss, and when I see a point that they're all agreeing upon, I'm like, okay, we agree. Okay, let's next topic. It's like that. You have to constantly be engaged. No. Unless sometimes in the community there is one person that everybody at the same level respects, then the jirga will be ultimately decided by him, because again, he's a constant. He's somebody that it's like a factor which brings everyone together. So let's stick to that one.
And mostly people like him will like decide that okay, we need to be 5 people or 10 people to decide this.
Yeah.
So it's like very much consensual.
Yeah. Yeah. Mm-hmm.
So there are no formal judicial roles in the community. And the other thing is, in the United States, we have things like Westlaw, legal reports.
Yeah.
There's written records of printed and written records of our
of legal cases, like
legal
precedents.
Cases, deliberations, decisions.
Yeah.
I mean, you're familiar. I mean, statutes.
Yeah.
The question is, apparently, I mean, I see that they have recognition of written documents, but they don't have any court records. That's why you mentioned very good memories.
Okay, so 2 things. One is that, in general, in a jirga that gets decided, there's not always some written confirmation that a decision has been made in this way. Because I was involved in this and being an international person would feel much more comfortable, I suggested that the parties sign something, which is what they did. But it is not like necessary, it's not something that is mandatory. 2, in terms of what I mentioned about registering it in court, that was something that was emerging like a hybrid. Like when I mentioned in Mazar-e-Sharif that they had a formal court system, but that many times the judges would refer cases out of the court to the community to resolve, I would then say, thinking in my Western way, that let's register this at the court. Like you do if you have a dispute here and you come to an out-of-court settlement, you register it in the court. Thinking that, again, the approach and the policy of the international community was to bolster the formal judicial system. So it was in my interest to ensure that as many documents were registered with the formal court so we could quantify these things. Did that make it more, did that give more teeth to the document? Did it mean that the parties were going to adhere to it anymore? Don't know. I was hoping that was what the outcome I was hoping for, that they would feel more compelled not to break the agreement. But one can never know, really. When it comes to the memory thing, it really is oral tradition passing on. Think of the civil law system instead of the common law system in terms of the way judges adjudicate processes in the European system. There are definitely statutes when it comes to particular things, but when it comes to the actual decision-making process within a courtroom, the judge is to rely on his own interpretation of that statute in a European system to decide a case. And the next judge who decides a similar case doesn't have to decide what the former judge decided. He can interpret the statute the way he wants as well. So this operates in that way in some senses, but there's no statute. The statute is in this case a value or a practice or a tradition.
There's no necessity in the European system to refer back to the
No,
previous interpretation.
not in a pure civil law system.
I see. And in this Afghan system as well.
Yes.
But there are, I mean, but to the extent that the judges at all.
I'm talking about the jirgas now.
The juries, yeah.
Yeah. Now with the formal system, there's a mix of civil and common. You had a question, and then Leonardo.
I had a question in terms of once you do your research and you find out what they are, how they work. I don't seem to understand why any money would deviate towards that, simply because I feel that that's very big, like they're very big right now because they don't trust the formal system, but there's things like that all over the world. In the US, you don't take all your disputes to the court. Sometimes you solve them within communities.
That's
So,
right.
wouldn't the aid still go to the formal system just to make it, and the better you make it, the more? So I don't see this fear that, I saw the judge and he really did not like the
Yeah.
idea of these. Why this fear that money's gonna deviate here? They don't, this is already happening, it's been happening long before. Why would an investment be made?
Well, I think two things. One is that the fear has become a huge fear. Mainly, it's like the fear is feeding over itself. So he's actually was a really extreme example of somebody who doesn't even really understand whether there's going to be an implication. He just knows it. But in terms of the aid, there is some truth to that. If, for example, we discover that 80% of legal disputes can be resolved informally with less financial investment from our side into the formal system because it's not being used, we won't invest as much money in there. So we may not decide to build a courthouse in every small village, which means that less judges may have to be let go. They may not, in a lot of these countries, the aid money is not always going to what's completely necessary. There are perks attached to those things, So the more money is diverted away, the less perks, and the more they'll have to spend on the basic infrastructure development, which, so it's really a corrupt thing, actually, reason. I mean, that's the bottom line. And we will reduce the money. No, the reason why the formal judges might feel afraid that donor money would get diverted away, because they're not needed as much. But it's now his fear is so he's so afraid he's not even rational. So Leonardo and then Malika.
What I got in terms of your research, you mentioned kind of two opposite propositions. One, that you find a lot of patchwork. You have different layers. The Soviet, the Sharia, the Western communal, it kind of all mingled and sometimes separate. And at the same time, you say that nonetheless there are some core set of traditions that kind of hold aside the whole thing. Do you have any hypothesis in mind in terms of where would things tend to be more oriented toward, like say a more kind of Sharia-oriented system rather than a more communal, strictly communal? What would be your take if you would have to choose kind of a guiding hypothesis to see what you're going to?
I mean, without being too committal, because I always fear with customary law, again, having dealt with it in Sudan and other places, that trying to identify core values can trap us into a narrow way of thinking and maybe promote the ideals of one particular community over another. At the same time, within Afghanistan, at least when you come down to numbers, there's a huge percentage of the country in the south which would be using the Pashtunwali code as an example. And so therefore that's a starting point in terms of looking at core values. Where it gets more difficult is in the north, where there's more ethnic groups. However, in the north, the formal system is much more pervasive and used. So we may not have that problem. It's really in the south and the east where we're running into the issue that people are not using the formal system and are mistrusting. And in the earlier part of my talk, what exacerbates that situation even more than the fact that it exacerbates that fact more is that we are unable to even go in and bolster and build the formal legal system structures there because of the insecurity. And so by default practices have pervaded there, but maybe they would anyway. So this is something that really needs to be looked into in terms of what would be. I do get concerned, especially when the military, this is, you know, my experience with the military, who are very operational in the South and the East, say, yeah, we figured out informal justice. It's this Pashto Mali code, and they give me like 5 things. That's one thing. The same issue happened to me in Sudan, where in southern Sudan, the winning tribe was the Dinka tribe. And in that situation, their code of custom, actually articulated by Francis Deng, wonderful special representative on genocide now, but a Dinka, and who codified what is customary justice in southern Sudan, which now traps us into, and all the other tribes are disenfranchised. So it's very complex. Malika, last question, I think.
So is something wrong in law and development and being in it, you know, having worked as an international lawyer, once you do figure out what the system looks like, what is the role for internationals in the system? So given the system allows people to express themselves or their individual identities in their comfort zones, all of that, what would the, you know, I could glean some of it from what you talked about this case, like you were telling them, write this down. But at the same time, these systems are prevalent as a form of resistance to Western impositions of
sometimes, yeah,
legal systems. Yes, in part, and also if they're, you know, supposed to be for the community, kind of within the community. How do you, what role do you see? You know, how would internationals implement? How can they?
Yeah, I mean, there's less of a role for us in that. That's the whole reason why the international community has started to turn towards the informal justice system, realizing that it's something that can emerge out of the community and be not only much more useful for the community and something that they want to access, but also less labor intensive for us. In terms of that, my interventions in this, it was actually, as usual with the international community, mainly selfish, to kind of figure out what can work in that system and what can't work and what does work. Where I do think we have a really important role is where, you know, in terms of how practices emerge and develop, in terms of ensuring that there are not violations of communities' rights or individuals' rights as per our perception of human rights standards. You just think about strict application of law, even in terms of Sharia law. We're in the United States, so death penalty is okay here, but let's say I'm a Canadian, which I am. That would be something I wouldn't understand, okay? Or just the way justice proceeds in an informal system. Just like we talked about not having documents, there's sort of a decision and then justice is delivered, and it can be sometimes swift and deadly. So how does this make us feel? Or in terms of, you know, revenge and you know, exchanging vows between family members to resolve disputes. These are things that sometimes the individual who's passed on in the process is not completely in favor of. Let's say it's a woman. So there are situations where we need to at least stay involved. We doesn't mean international Westerners, but there has to be maybe some support for developing these processes from the international community. How much of a role, I don't know. I mean, Siick, yeah.
What benefit that will give, like if we are not able to spend billions of dollars on the formal justice system, which is very small in Afghanistan?
Yeah.
So how do you see that it will help or benefit the informal justice system of Afghanistan when we say that we should interfere? But for me as an Afghan lawyer, the informal justice system, I'm very much happy with it, the way it is working, although it has its own defect. You say there are some, but I would say there are gross or there are numerous human rights violations. Let it be the same as it is. I'm sure that if there is any interference or any work in it, it will not work, but it will like kind of worsen it when the issue of we say that we get there, then I believe that it means money should also go there. So as soon as money is there, we will make it more corrupt like the other institution of Afghanistan. So for me, I would say that let it be as it is, work on the formal justice sector, and beside that, certain things or steps should be taken to kind of penalize certain defects that we have right
Things
now.
that violate
So my
rights.
question is again, like how do you see that it will help?
Yeah. No, I don't know. I mean, Malika was posing whether there should be involvement in the international community. For me, I'm not sure whether or if or how much the international community can be involved. I do definitely think there's still some need to identify where certain practices are not in compliance with some basic rights and beliefs that we are holding, and that's still important. How we do that, we don't sit around in jirgas, no. But how we do that, how we advise communities, how we encourage them, maybe it's a sharing of information in terms of intellectual to intellectual, but it's a long process. So yeah, I don't know. And in terms of your point about the formal justice sector and staying involved, true, but not to the extent we have been, because we are spending more money than what is the actual size of the formal justice sector, because we're just pouring money into mechanisms that don't work. So that's where we need to be careful. We need to pare down what we're doing. 1, 2, I don't want to keep people too long. I'm sorry. Jude, and then thanks.
Yeah, for me, the question is actually, I agree with Siick, to a certain extent. But I also want to say that, informal justice is actually very good because, people are confident, so it brings about, some pride with the, people with the, like, the natives down there in Afghanistan, and But okay, my question is, do you know the hierarchy of the judicial hierarchy of Afghanistan? Are informal, informal justice, is informal justice supposed to be a subordinate of formal justice?
Right. You mean in terms of,
Yeah, in terms of, the legal system.
Yeah, thinking of the African
does
context.
It have to depend on the formal justice to make, good decisions and everything? Because I think, for me, I understand the Constitution in everywhere is actually the supreme law.
Yeah.
So all these other laws have to depend on it. So does the Constitution actually is it affected by the...
Okay, and I, understanding your question...
Repugnancy and inconsistency.
Yes, understanding your question from the African context, because for example in Nigeria, even though they have strong customary practices in law and Sharia law, the Constitution is the supreme document, and actually customary law principles, especially in the African context, South Africa, Nigeria, Sudan, has been incorporated into the Constitution. Not so in Afghanistan. So right now it actually is kind of two parallel ways of going. Constitutional amendment, not going to happen soon. The question in terms of conflict of laws or repugnancy, so a decision is made at a local level which is in violation of the Constitution. I don't know of any cases in which somebody has gone to the court saying, I went to a jirga, it didn't give me the decision I want, and actually it's in violation of the Constitution. Siick may know of some cases, but I have not heard of any cases. But I don't think that it's unimaginable that somebody would eventually think to take the outcome of a jirga to the Supreme Court, because already, Afghanistan has been a bit slow in terms of using the Supreme Court to verify and to confirm constitutional rights. So bring cases that decisions that are made at the district level up to the Supreme Court for constitutional decision. Compared to other countries, there hasn't been that many, but it's starting to happen. So that actually should be a very creative thing. The problem is, in a customary system or the jirga system, there aren't lawyers. So in terms of some elder in the community or a grieved party in that jirga going to the Constitutional Court, there would have to be some smart lawyer who told them to do that. So I think that it hasn't happened yet. And I think I'll let Siick, and then you have a question, and then we can...
Well, I was just saying,
Yeah.
the question was, we may have already answered it. So you have a decision in the juridical level and informal study. Do
Yeah.
any of those ever reach the formal sector?
No, I mean what normally happens is that if somebody's unhappy with the jirga outcome, they'll go to court anyway, but it's like starting over again. They can't go, they won't, I mean, they'll probably say in their witness statement to the judge, oh yeah, we tried to resolve it in the community and there's a transcript about it. But how much the judge has to take that into account or not in terms of the facts, it's not really officially required.
You say that there is a transcript of the informal decision?
No, I'm saying
You say there isn't a transcript?
there isn't.
I misheard you.
Yeah. There usually isn't. I mean, I don't know whether in, for example, these test cases that are being done in Khost province in Helmand, where the international community is monitoring local NGOs who are observing jirgas, whether they're writing it down. It's not an official court record, but I know in Norwegian Refugee Council, when we were looking at land cases and we were observing jirgas, we would write stuff down. So we had a transcript, but it's not an official court transcript or anything. You know, it's not evidence that's entered into. It's our case files. In fact, when I worked in Afghanistan and international or local NGOs were providing legal advice, there was, I mean, huge questions as to whether even the member of the local NGO, a national staff of our legal department, who was a trained lawyer, was actually able to represent clients because he wasn't maybe registered with the Ministry of Justice. There's been a huge change in the formal sector in terms of accrediting and training and creating a bar association in Afghanistan, of which Siick is a member. But when I was there, that was when that was starting. So these were basically just NGO advocates, even though they were trained lawyers. And in fact, I hired mostly academics. So now that's why I want to go back to actually see how that's operating and functioning, whether there has been a shift with the professionalization of the bar to more interchange between the two systems. Last point.
Are there any organizations or advocates advocating actually the informal justice there in Afghanistan, or are there actually people there trying to advocate in an organized way the informal justice, and is the judiciary actually there, educated about this, or do they actually undermine the informal justice?
Well, they undermine the informal system for the reasons we mentioned earlier.
Is the UN actually also
the what?
aware? The UN, the United Nations.
The UN, yeah. They're aware of everything. That's all I'll say. But in terms of the in terms of the formal the judiciary is aware. I mean, they are Afghans. They, in fact, when it comes to personal matters, use the informal system, okay? Which is, because personal matters, personal law, land, family, is a very personal thing in Afghanistan, and it is adjudicated that way. In fact, Abdul Rashid said that himself, in fact, for personal matters, But in terms of, what was your other question about the...
My other question was, is there enough jurisprudence, like the international community? Is it really very, like for example, to advocate for this on the international community level? Is there enough jurisprudence? Are people really interested in, learning this? Because this, I think, may help diplomatically informal justice.
Well, that's what has happened in the past. Some international national NGOs have documented cases that have been resolved using jirgas, particularly in land disputes or family disputes. And that's why it's been emerged that it's a very important mechanism that is functioning in Afghanistan to make decisions on particular areas. Since that happened, the next question was always, if it's so important, maybe that's why the formal system is not being used, and why is it so important, and why do Afghans like it? And we still haven't moved to that level. We're still doing pilot testing in different parts of Afghanistan on different cases. So we we are now at the point, and that's why I'm trying to embark on this research, which is that we realize it's important. We realize it covers a wide variety of legal issues. We realize that it's not as repugnant to human rights for the involved parties in the case that we think, or maybe, we need to look a little bit more at why this system is so popular and how it can emerge in a society like Afghanistan, in which there are some frameworks that have been sort of prescribed under the Bonn Agreement and within the Afghan government on how they would like their society to function.
Make a comment?
Yeah.
I think national institutions like a judicial system are related to each other, related to government, and related to the educational system. And my impression of Afghanistan through recent reading and learning about it is that it's a very fractionalized country, very different ethnic groups, and just things you've been describing. Yeah. So, and there's lack of trust in government and lack of security right now. So, long term, in this country and in other societies, we learn as children in the educational system how our government works and how the courts work and how the judicial system works. And we begin to trust it, and we have some rudimentary understanding of lawyers and courts and justice and the rule of law, the laws, the legal system. I don't know that exists in Afghanistan in terms of a standardized, everybody in Afghanistan, whether Pashtuns or Uzbeks or other groups, feeling that, we're all Afghans and we all have this standard law. I don't know if that exists yet, or even if there's a national education system with standardized education through all the regions of Afghanistan. Pardon my ignorance.
Yeah.
But until there is standardized public education where everybody's children are getting the same message about the government institutions, and the legal system, I don't see how everybody is going to accept ultimately a standardized formal legal system until you have that other institution called the educational system functioning.
Well, the key flawed assumption in what you're saying, you're correct that if everyone was educated about a formal system, they might want to use it. They might understand that it's there. The flaw, I think, in that is something that I mentioned in the beginning. I don't think that's the way Afghans operate, or that kind of society operates, that the informal justice system does work to resolve disputes, is fair, has value, respects community, engages everybody. And therefore, there's no reason to substitute it with the formal system. One, add to that layer that the formal system has been racked by corruption and mismanagement, makes it even less trustworthy. So, but even if you were able to eliminate that, it's a great formal legal system. It works, it's not corrupt, it's efficient. Everybody knows about it. My prediction, and actually the reality on the ground, shows that people will still use the informal mechanisms to deal with at least personal matters. Family matters, land matters, inheritance matters, matters like that. For a long time in Afghanistan, criminal law and commercial law has been in statute, and the formal legal system is how those cases are adjudicated. That's not going to change, but it's obviously gotten worse with the corruption and mismanagement within the legal system. Even people want to try and take criminal matters out of the formal system. But that's not something that the international community nor Afghans want to change, because historically, when Afghanistan was in the control of Afghans, King Zahir Shah and others, that's when these reforms were made to create statute for criminal law and for commercial law. So that's something that's Afghan owned anyway, and that's the key. So I don't think, and in terms of widespread public education, and even with all of that in mind, think of, it's a communal and community-based society anyway. Fractionalized is definitely the way it is now, but it is a communal-based society regardless.
But if you want a centralized government, you have to balance that with some centralized control.
Well,
which
my-
needs some level of standardization.
Yeah.
I don't know what's right, but I'm just
No,
saying.
no, and I agree with you. And I think that the starting point of my research is actually that I'm not sure that a centralized, and I know I would have a debate even with Afghans, a centralized system is ever going to work in Afghanistan. Last point. I'm just thinking I think somebody's coming in at 6, that's why.
Just wanted to add on.
Please add. Yeah.
This is a very good point. Education in Afghanistan, when we look at the literacy figures, it's very much arguable. Some say that 15% are educated, some say even less than that, some say up to 7%, so we do not have precise figures for that. But in terms of the legal awareness among the people, I think the government has taken the right step right now. Constitution of Afghanistan is taught in different classes of school right now, which is very good. At home, like I was one day very shocked that my little sister came in and she was asking me a question related to Constitution. I was shocked at how you know this. She said, we are studying this. And I was bringing me a book, and she brought the book, and there were certain provisions of the Constitution. And I was very happy to do that. So this is like kind of the step that is taken by the government, and the legal awareness being created right now.
Yeah, there's a lot more than there was before. I mean, that's something that the international community can be proud of in terms of how they have been able to work with Afghans to do that. Education's been one of, a success story to some extent. But with all that in mind, still, whether people will use that within their family environment, use the legal mechanisms, which are corrupt, cost a lot of money, and which don't really give you justice. What's the difference? My argument is mainly to provide a space, to look at Afghanistan and see what is going to work for, where the informal system is going to be more dominant and where the formal system is going to be dominant. I'm not an advocate for eliminating one or the other. And the way our foreign policy and our system, our approach to Afghanistan is going, if you follow the policy of bolstering the formal system to the logical end, like let's say we had all the money in the world, it would be eliminate the formal system. If you followed it to the end. But we're never going to do that because we're never going to be there that long. So in absence of that, if one wants to think in the way that okay, the formal system is better, but we're not going to be in Afghanistan long enough, therefore we can't do it, and it makes you feel better. If you don't actually want to, not you, but if one doesn't actually want to embrace the idea that the informal justice system is appropriate, then actually, unless you want to stay in that country for more than decades, to actually roll back, years of historical development, and even with that, it's probably not possible. So it's kind of one of those things where we just have to kind of find out where different things work in different places within the country and know more about the country, which we don't. That's the sad part. This is a very good example of the judicial sector development, where we actually have never bothered to really figure out what Afghanistan is all about in terms of legal decision making. We've done a very good job in Kabul and in the cities. We understand the formal system, but we do not understand the informal system.